Okay, I'm recording the class. Okay, so for this week we are looking at Unit 15, Auditors. I'm pretty sure, seeing that you're studying accounting, you all find this particular unit very interesting. Doing Unit 15, Auditors. It's not a very long unit, but it is quite an important unit. I'm busy setting your end of semester exam, and I can already tell you that there definitely is a question in the exam based on Unit 15. So just to make sure that we are all on the same page, when I speak of auditors in this unit, I am referring to the external auditor of a company. Many companies, especially your larger companies, have their own accountants, etc., etc. And very often they also have internal auditors. These are not the people I'm talking about in this unit. In this unit, I'm referring specifically to the external auditor of a company. Companies Act requires that every company's financial statements must be audited by an external auditor during every financial year. So companies have to appoint external auditors. Let's just go to the slideshow. Okay, just confirm to me, give me a thumbs up. Can you see the slides? The spheres can see them, normal can see them. Okay, so just remember meeting protocol. While I'm teaching, I'm focusing on the window that has the slides. If you have any questions or comments, please feel free to interrupt or alternatively put your question in the chat box, but feel free to interrupt me. Okay, so our learning objectives there. Remember always to go through the learning objectives, as I'm always saying. Make sure that you can address the various learning objectives. So as I said, in terms of the Companies Act, it is a requirement that every company must have external auditors. The role of the external auditor is very important. It takes us back once again to where we started when we started talking about companies, namely the fact that it is a unique characteristic of auditors, of companies, sorry, that there is the separation between ownership and control, between the shareholders on the one hand and the board of directors on the other hand. Kept on coming back to this. There are various provisions in the Companies Act that are there for the sake of protecting the shareholders. Remember, the shareholders own the company. But in terms of the law, there's a board of directors that manages the company. that manages the property of the shareholders. And you can imagine that could potentially be quite easy. Let's put it this way. Part of the management task of the board of directors is the preparation of annual financial statements. These annual financial statements are prepared by the company, by the accountants, whatever in the company, and ultimately signed off by the board of directors. So it could easily happen that if directors are busy with funnies, that they could cook the books, so to speak, and hide things in the financials. And that is where the requirement for a company to have external auditors come in, because it is their job to check these annual financial statements and make sure that the directors are not doing anything funny. The directors are not hiding things. So they play a vital role as part of the compulsory disclosure and transparency requirements that are central to the Companies Act. As such, it is a requirement of the external auditors that they must have a high level of professional competence as well as a high level of independence. So that's the cornerstone of an external auditor: professional competence and independence. Which brings us to the first question, namely, who may be appointed as an external auditor? Companies Act, however, does not approach the question from the positive, doesn't ask or say who may be appointed, rather similar to what we approach when we were doing company directors. Rather than saying who may be an auditor, it specifies who may not be an auditor. So there's a whole list of bullet points there, 1, 2, 3, 4, 5, 6 bullet points. Looking at that last one first, it says that a person who is not qualified to act as such under the Public Accountants and Auditors Act may not be appointed. So to be appointed as an external auditor, this person must be a chartered accountant, must be a registered auditor in terms of the Public Accountant and Auditors Act. It can either be an individual, which is hardly ever happens, that's unlikely. In most instances, it is a firm of auditors which is appointed. So that last bullet point, the reason why I did that first, that last bullet point takes us to go back to the requirements. It says a high level of professional competence and independence. That first point there, high level of professional competence, is addressed by the requirement that the person must be qualified to act as such under the Public Accountants and Auditors Act. The rest of the bullet points refer to the issue of independence. So who may not be appointed? Firstly, a director, officer, or employee of the company. So nobody who is directly connected to the company as a director, officer, or employee of the company may be appointed as external auditor. Please be careful there. It says a director, officer, or employee. It does not say shareholder. A shareholder may, in fact, be appointed as external auditor. So remember, the purpose of the external auditors is to protect the shareholders. So disqualified director, officer, or employee, shareholders may be appointed as external auditors. Second bullet point, a director, officer, or employee of any other company performing secretarial work for the company. Secretarial work, in this instance, not referring to somebody that does the typing, but company secretarial work. Your large public companies all have their own company secretaries, or not always, but most often have their own company secretaries. But smaller companies can often not afford to have a full-time employee as company secretary. But annually, there is a lot of prescribed company secretarial work that needs to be done, returns that must be filed, etc., etc. So many companies contract this out. There are companies, other companies, businesses, use the word businesses, that are in the business of offering company secretarial work. Now, if whoever's company, let's say Alexandra has a company. Alexandra has a company, and Normal has a company that does company secretarial work. And Alexandra's company employs Normal's company, Normal's business, to do their company secretarial work. This provision provides that a director, officer, or employee of any other company, so Normal's company in my example, cannot, if they're doing the company secretarial work, they cannot also be the external auditors. A partner, third bullet point, a partner or employer or employee of a director or an officer of the company. This relates to non-executive directors. How to explain this? Let's say Maria is an external director, a non-executive director of ABC company. But Maria is employed elsewhere in another business. Maria is a chartered accountant. She works for a firm of chartered accountants. In her personal capacity, she is elected as and appointed as non-executive director of ABC company. That means nobody from this board of this auditing firm where she works, her partners, her employer, her employees, may not be appointed as external auditor. In practice, this can sometimes be a bit problematic, because chartered accountants, because of their financial and accounting knowledge and their business acumen, are very often, they're very popular to be requested to serve as external, sorry, I'm not thinking tonight. Chartered accountants are very often very popular to serve as non-executive directors because of their financial expertise, etc., etc. But if a partner, or if an individual partner of, let's say, PwC, serves as a non-executive director of Bank Windhoek, that means PwC as accounting firm cannot legally be appointed as the auditors, the external auditors of Bank Windhoek. So there could be a bit of a juggling act. It might be flattering or compliment for Maria to be requested to serve as non-executive director of Bank Windhoek, but at the same time, she rules out the whole of PwC as being their external auditors. And of course, external auditors get paid well. It's quite lucrative. So it could be a bit of a sort of a balance of interests. Next bullet point is related to the previous ones. A person who personally or whose partner or employee habitually or regularly performs the duties of secretary or bookkeeper of the company, similar to bullet point 2. You cannot suddenly resign as director with the hope of being appointed as external auditor. Any person who at any time during that financial year was a director or auditor. So even resigning doesn't make you eligible for appointment immediately. I don't have a slide, just mention it. With regard to that particular prohibition, you know by now that very often, or that the Companies Act is written for public companies and then makes exceptions. With regard to that bullet point, there is an exception for private companies. In case of a private company, an exception is made to the rule that a person who personally or whose partner or employee performs the duties of secretary or bookkeeper may not be appointed as auditor. Such a person may be appointed provided that they are qualified, registered accountant auditor, all the shareholders have agreed in writing to their appointment, and the relevant circumstances are stated in the auditor's report. So for a private company, there is an exception as to these exclusions. Person who performs the duties of secretary or bookkeeper may be appointed, provided all the that they are duly qualified, all the shareholders agree in writing, and this is set out in the auditor's report. Any questions so far?
We are good, ma'am.
Okay, thank you. Thank you, thank you. Okay, let's carry on. Oh, I do have a slide. Sorry, I didn't realize I had a slide about this. This is a repetition of what I've said. Person may be appointed who performs the duties provided those 3 requirements have been met. Now, I stated earlier that the external auditor can either be an individual, or that's very actually rare that a specific individual is appointed. In most instances, a firm of auditors is appointed. So PwC, EY, Grant Thornton, etc., etc. You will recall, because all these auditing firms are partnerships, and you will recall that when we did partnerships, we actually learned that If there's any change in membership in a partnership, the partnership terminates. So you can ask yourself, but does this perhaps have an effect on the appointment, that particular firm's appointment as external auditor? General answer to that is no, it will not have an effect. A firm of auditors may be appointed as external auditors if there is any change in membership of the composition of that firm. So a partner has resigned, or a new partner has been admitted to the partnership. This will not have any effect on the firm's appointment as external auditor, unless 50% or more of the partners of that firm resign at the same time. If there's a change in composition of the members and less than 1/2 of the members remain, this will be interpreted as the resignation of the external auditors, and a casual vacancy will arise. What we mean by the term casual vacancy, we will be getting to shortly. But if there's 5 members in the auditing firm and only 1 resigns, doesn't matter, they can continue. So how are auditors appointed? The very first auditor of a company is usually appointed when the company is registered. Part of the documents that are lodged with BIPA, with the Registrar of Companies, together with the Memorandum and Articles of Association, is a document whereby the first external auditors accept their appointment. So they are appointed then when the company is registered. If somehow this didn't happen and no auditors were appointed when the company was registered, then the directors of that company must, within 21 days after registration, must appoint the external auditors. 21 days have passed and they haven't done so, the Registrar of Companies will appoint an external auditor. The first auditor then is so appointed until the first annual general meeting of the company. The Companies Act doesn't talk about, or that directly, about changing auditors. It rather refers to the reappointment of auditors. Companies Act states that at every annual general meeting, it's part of the standing agenda of a company's annual general meeting, is the appointment of the external auditors. Auditors that are appointed at an annual general meeting will hold office until the next annual general meeting. They cannot be dismissed by the company, either by the directors or the shareholders, in between the annual general meetings. Companies Act, however, provides that at every annual general meeting, the external auditors are deemed to be reappointed. So in fact, the annual general meeting just confirms that they will continue for another financial year, unless those 3 circumstances arise. they are not qualified for reappointment, the annual general meeting adopts a special resolution replacing them, appointing somebody else, or if not appointing somebody else, at least expressly providing that they are not reappointed. Or if the existing external auditors have given notice in writing to both the company itself and the registrar that they are not willing to be reappointed. So in fact, they are indicating that they are stepping down, that they are resigning. So just to recap, first, external auditors are appointed when the company is registered. They will serve until the first annual general meeting. From there on, at every annual general meeting, auditors are reappointed. Those auditors are reappointed unless a special resolution is adopted stating that they are not reappointed and appointing somebody else. If for some reason external auditors are not appointed at an annual general meeting, the company's directors or the registrar of companies must then fill this vacancy within 30 days. I've stated previously that in the previous slide, they hold office until the next annual general meeting and cannot be dismissed. That doesn't mean that these external auditors are bound, because they can resign. There's a difference between resignation and being dismissed. Auditor can resign at any time during their period of office. When they resign, they must submit a written notice that they have no reason to believe that there's any material irregularity in the financial statements of the company, or if there is, that such irregularity has been reported. If the auditor resigns before the expiry of their term, in other words, before the annual general meeting, anytime between one AGM and the next AGM, that is referred to as a casual vacancy. So casual vacancy arises when the external auditors resign before the next annual general meeting. In the event of a casual vacancy arising, directors or the registrar of companies must appoint new external auditors within a period of 30 days. So how are auditors removed? We've looked at how they're appointed. They're appointed at the AGM, and under certain circumstances, if there's a casual vacancy, they can be appointed by the directors. Now remember this, because it becomes relevant to their removal. Removal, we've already seen, can only take place at an annual general meeting. If the intention is to remove or replace the external auditor, special notice must be given. Quickly, somebody, can you tell me what is special notice? We came across special notice in Unit 8. What is special notice? How many days?
21 days.
It's not 21 days. Special notice is not 21 days. Special notice,
I think it's
remember?
28.
28 days. 28
Yeah,
days.
yeah,
Remember
the one
that.
for of what? The removal of a director.
Removal of directors and removal of external auditors requires 28 days notice, special notice. Remember that. So it's not just 21 days, it's 28 days. So if, in general, normally, under normal circumstances, notice for an annual general meeting is 21 days. There you were correct, Arunisia, and normal. But if at that meeting they are going to be removing the external auditors, 21 days notice is not enough. They have to give 28 days notice. So a longer notice is required than for normal annual general meeting. The external auditor must be informed of the intention that they are going to be removed and must be granted the opportunity to make written representations to write why they should not be removed. They must also be given the opportunity to state their case, to make oral representations at the meeting. Let me put another bullet point in here. At this annual general meeting then, I've already mentioned it in that slide. If I can go back, it says, I said refer to a special resolution appointing somebody else. So, oh, I actually had it there, sorry. Special resolution at an annual general meeting. So directors, let's just recap. For the removal of directors, you need special notice, but an ordinary resolution is sufficient. For the removal of the auditors at an annual general meeting, you need special notice, but a special resolution, 75% majority is required. There are, however, some exceptions where, in fact, the external auditors can be removed by way of an ordinary resolution. You still need special notice. Special notice you always need. But you can have an ordinary resolution at any general meeting. So not just the AGM, at any general meeting. In the instances where the external auditors were not appointed by the shareholders, where they were appointed by the directors. So when there was a casual vacancy, if there's a casual vacancy, the directors must appoint auditors within 30 days. If the shareholders are subsequently not happy with these auditors that the directors appointed, they don't have to wait until the next annual general meeting. They can remove those auditors that were appointed by the directors at any general meeting that was called. So anytime, not just wait for the AGM, they can call a meeting. Still requires special notice, still requires 28 days notice, but then a simple majority, an ordinary resolution will suffice. They must, however, if the auditors are removed at a general meeting in this manner, they must immediately appoint another auditors at the same meeting. So they can't just call a meeting and say, no, we don't want these people as external auditors. They have to come up with a suitable replacement. Any questions?
So, ma'am, are you saying that these auditors cannot, under any circumstances, be removed without having suitable replacements in line?
The Companies Act provides that a company must have external auditors. So you can't remove them and decide we're going to go ahead without external auditors, no. If you remove them, you have to replace them.
Oh, okay, noted, ma'am.
Okay.
I thought it would just work like any other normal employees, whereby you just fire them and then look for them at a later stage. But okay, I get the point.
No, you cannot. Companies Act provides that a company must have external auditors at all times. So if you've removed them, you have to immediately replace them. Otherwise, the registrar of companies is going to do the job for you and appoint them on your behalf. Other questions? No further questions. Okay, the rights of the auditor, I'm not going to go through that. That is discussed in the notes, not in much detail. I never do that in detail because you do that in great detail when you do auditing as part of your Bachelor of Accounting. So I'm not going to stress about that. Similarly, the duties of the auditor, I also don't do in detail because once again, you do auditing 1, 2, and 3 in where you study the duties of external auditors in detail. So I'm going to stop here for now. On Wednesday evening, we will look at the issue of confidentiality, just very briefly. I also don't do that in detail because you also do that in detail in auditing. And then very importantly, the potential liability of the auditor. We will look at Wednesday evening. In the meantime, I have some homework for you. Those of you that like browsing the internet or reading the papers, I came across this, it's an ongoing issue, but it's very much in the news at the moment. Found it very interesting, and it directly relates to what we're going to be doing next week. Please browse the internet a little bit and read up about what is currently happening with PwC in China. Now, we study Namibian law, not Chinese law, but the principles are actually very comparable. And there's a big mess, big drama at the moment with PwC China, where essentially they messed up as external auditors. And they've been fined bags and bags and bags of money, and all sorts of horrible things have happened to them because they were not doing a proper job as external auditors. Go and see if you can find anything in the news about that and read that, because next week, Wednesday's class directly relates to that. Last questions?
Good evening, ma'am.
Good evening, Aronisia. Have a lovely evening.
I just wanted to find out, did you already post the solution of test one?
I haven't. I have not. Thank you for reminding me. Thank you for
And
reminding me, Aronisia. I will do that.
and also the other question is, will there be things of the other units in test two,
What
except
does test
unit
What does test two cover?
unit 9 to 15?
Yeah, Aronisia, the thing about company law is you cannot completely separate the units. In order to answer questions about units 9 to 15, it is essential for you to have knowledge of the earlier units as well, like the different types of companies, the types of shares, all of that. Will inevitably be sort of integrated. So the questions, I won't ask questions that come straight out of the first units, but that knowledge is indispensable, because you will be required, even in when answering a question, for example, about capital maintenance, whether it's a public company or private company could be relevant to your answer. So company law forms a whole. You can't forget about units 1 to 8 now. But I'm not going to ask you to calculate whether a resolution was properly adopted, because that's straight unit 8, if you understand what I mean.
Okay, ma'am.
Okay, lovely. Thank you.
Good night, ma'am.
Bye. Good
Thank
night.
you.